what is generally considered, what are you talking about when we talk about employment law? Employment law. What does that entail? Employment law. Mr. Ave, what is employment law?
Employment law would be any law that regards the hiring of employees.
The law that involves the hiring of new employees. Employment law. Okay. Mr. Fitzgerald. That's you, right? That's you. Okay. You, Fitzgerald. Mr. Fitzgerald, what do you think is involved with the concept of employment law? Mr. Fitzgerald?
Alright, employment law, I would guess, like offhand, it's the laws that are tied with employees.
Employing, so when you say employing employees, what does that mean?
Like the stipulations that go behind employing them, like maybe regulations that they have to go through.
So again, if you are the employer,
Okay.
right? If it's your job, what is it that you want to do, Mr.
I want to find the right employee that fits my, I guess, company.
So you want to first find the right employee, then what you want to do after that?
Hire him.
Hire him, and then after that,
Make sure they stay on task.
make sure that they stay on the job, right?
Right.
So again, when you talk about the federal laws, right, that regulate employment, that means, as you talk about, Mr. Fitzgerald, those are the laws that give rights to who?
The employees.
Employees. And they give obligations to who?
The employers.
To the employers. They're also inclusive in that are provisions and stipulations that also give rights to the employers, right?
Mm-hmm.
So again, when we talk about employment law, that's what we're talking about. And there are 1, 2, 3, 4, 5 main federal labor relations laws. How about, do you know any of those?
What?
Any of the main labor relations laws? I'll let you go ahead and say, we'll give you that credit, Mr. Fitzgerald. How about you, Mr. Ave? 5 of the major federal employment laws. Affirmative action is a concept, but it's not considered one of the federal labor relations laws. Again, those laws that specifically govern union activity in the context of the employment of the workspace. So I'm asking you, affirmative action, that's actually a policy, not necessarily a law, right? But we're going to get to that policy later on. But I'm asking you now, what are the primary labor relations laws? Let me ask Mr. Jackson. Mr. Jackson, is that Mr. Jackson? Mr. Jackson.
Yes, sir. So the 5 federal labor relations laws is the Railway Labor Act,
The Railroad Labor Act, 1.
the Norris-LaGuardia,
Norris-LaGuardia Act, as in LaGuardia Airport, in what city? LaGuardia, New York. All right. 3.
the Labor Management Relations Act, originally passed as the Wagner Act, amended by Taft-Hartley and Landrum-Griffin Acts.
Exactly. The Labor Management Relations Act.
The Landrum-Griffin Act,
Landrum-Griffin Act,
and the Civil Service Reform Act.
the Civil Service Reform Act. Thank you. You're welcome. Jackson. All right. And we can come back to you. So let's get into what the idea of these laws are. So again, when we talk about these statutes, we know that these laws come about through the interaction of labor unions and their constituents, as well as the interplay and the protection of the interests of the actual employers, right? We talked about some of the struggles that workers went through over the years in Chapter 2, and some of the things that they had to actually endure, to get their rights, some of the brutality they faced by both the employers and unfortunately also the government. But in some cases, laws were passed to try to address some of these protests and some of these strikes that were taking place. And the first one that was discussed was the one passed in 1926 when the Railroad Labor Act was enacted. So let's talk about the Railroad Labor Act. And we know that it applies to rail and air carriers. That is people who are responsible for, basically transporting the stuff that is carried by rail as well as the stuff that is carried by planes. And they are non-managerial employees. So the Railroad Labor Act of 1926 has 5 general purposes. Ms. Latney, what are those 5 general purposes?
Avoiding service interruptions, eliminating any restrictions on functions of the union, guaranteeing the freedom of employees in any matter of self-organization, providing for prompt dispute settlement, and enabling prompt grievance settlement.
Absolutely. Thank you very much. So again, in railroads in particular, we got train drivers, maintenance, away employees, conductors, ticket agents, shop workers. These are some of the people who are covered, right? Whether they're involved in actually moving passengers or freight. So it doesn't make a difference whether you're just moving, or you're on Amtrak, where you're involved in moving passengers, or you're involved in moving freight on the CXX or other railroad lines, right? The same way.
It's 5:30.
Thank you. You have also, in the context of airline, you have airline pilots, you have cabin attendants, mechanics, reservation agents, baggage handlers, and these are the people are covered there. In 1996, the Federal Aviation Authorization Act brought air express companies such as FedEx within the jurisdiction of the Railroad Labor Act. However, there was a company that was kept out. Why? What company was kept out, and why was that? Mr. Mason.
Say, which company was kept out of Railroad Act?
Mm-hmm. Help him out, Ms. Mathis. A company that was kept out of the jurisdiction.
UPS?
UPS, United Parcel Service. And why were they kept out? Yeah, go ahead.
Since FedEx is considered primarily an air express company, while UPS is seen as a primarily a ground carrier.
Exactly. So again, this was about the rail and air, right, carriers. Since UPS, all of us, we know UPS, right? The brown trucks, right? They carry stuff, right? UPS, unlike FedEx, was just considered a rail company because the majority of their stuff is taken by, huge semi trucks, basically. But FedEx, they have what? Planes, right? So they fly all the stuff down to Memphis and then redistribute stuff around the world, right? From Memphis. So that's the reason why those two distinctions were made, all right? And so we'll give you that, this math is, and so Mr. Mason can continue to stay with us. So Mason, so tell me, what are some of the main differences between what does the RLA enable employers to do or employees to do? What's the rights it gives them?
The RLA enables employees to choose by majority vote an organization to exclusively represent them for collective bargaining purposes.
One, it gives, again, employees the right to have a vote, and based upon that vote, to choose one labor union to represent them for the purpose of what? Again?
Collective bargaining. Collective
bargaining. And what does that mean again?
Coming together and bargaining for, like, your worker rights.
Yeah, bargaining a employment contract, not individually, but what? Collectively. All right? So that's the first thing.
Want me to continue?
Second,
under the RLA, employees within a given craft or occupation are entitled to be represented separately within their employees. And initial representation elections are held within a single defined occupational group.
so again, you can have exclusive representation by one union for collective bargaining. However, employees within a particular occupation can be represented separately within their employers, and the initial representations representation elections are held within a single defined occupational group. So what that means is that you can have a company that has all the employees there represented by the same union, right? Option A. Option B, you can have all the types of employees represented by either the same union or a different union, right? So in essence, for example, you could have the baggage handlers for several companies. Some of them might be represented by one union in one company, and then in another company, even though they're thank you, and even though they're in the same occupation, since they're in a different company, they can have a different union representing them, right? But generally speaking, if you're in the same occupation and in the same company, you're going to be represented by one union. All right? What else?
Unions or associations seeking to represent employees must be free of employer domination or assistance.
Exactly. So that means that unions are supposed to be free, independent of the employer's control. So the employers cannot dictate to the union, what they should do. And that's one of the reasons what we talked about before is how when you're hired, when you get elected as a union representative, as a part of the contract that you negotiate with the company, that company agrees to pay that that union representative, even though he or she is not doing the company's work. So the company is paying the shop steward whatever his or her salary, and then that shop steward is doing union work for whatever the length of time that person is in that office. Or if it's a president, then that person is full-time, although the shop stewards are generally not full-time union representatives. They're generally full-time employees, but they spend part of their time working on the issues related to the other members of their union, okay? What else can you give us about that?
Majority representatives become the exclusive bargaining agent for the employees within the bargaining unit and are entitled to negotiate with the carrier over wages, terms, and conditions of employment.
So again, that means that the majority rules that a contract is submitted, right, for approval by who? It's submitted for approval by who?
RLA? Or
The contract is submitted.
Employees?
Employees, and that is decided by a minority or a majority. Majority. So that means that there's a what? A vote. Up and down. Do you like the contract or you don't like the contract? Right? If you like the contract, then the contract is what? Ratified. If you don't like the contract, you have to renegotiate it, right? Or you go on strike. Or that there's a lockout. Okay? So that's what we talk about there. The last issue is what?
Negotiated contracts must contain a grievance procedure consistent with the requirements of the RLA.
Now, that's a key point. So, in addition to having, again, unified terms of your contract, you have to also have a mechanism by which, if there's a problem, you can actually deal with that, as opposed to actually having to fire somebody. That's the key issue. That's a very key term. Again, a mechanism, or, so again, the employers might have a right to fire the person, and the employees, they have a right to do what? Fight where? Fight, well, in addition, again, outside, if there wasn't a grievance mechanism, what would that person be doing? Fighting where?
At their job.
Fighting
In court.
in court, right? So again, having this grievance mechanism, it keeps people employed on the one hand and keeps people out of court on the other hand. You see what I mean? So it's a win-win type of section. So again, that's like the grievance mechanism. Very key component of any, again, labor contract is a mechanism by which disputes, whenever they arise, and they're definitely bound to arise, can be resolved by the parties themselves without having to go to court. All right? So that's the major elements of the Railroad Labor Act, and that Railroad Labor Act serves as the guidepost, right, for the rest of the laws that cover the other areas, right? That serves as the template, if you will. All right. So thank you. You can have a seat now. So now, tell me, how are contract negotiations different than in other private sector and public sector laws under the RLA? That was Miss. Who was that? That was Mr. Who got that? That was Mr. Mason. Mr. Mason. Okay. So let me just take a time check right here. It's 5:45. We're going to. So again, let's talk about the Miss Olatunji. Miss Olatunji, tell me, what are the differences between the RLA, or how are contract negotiations under the RLA substantially different from those contractual negotiations or contract negotiations under other private sector and many public sector laws?
The contract remains in effect, and after its stated amendment date until a new agreement is reached. Before a contract can be amended, written notice must be given 30 days before the intended changes would go into effect. At this point, the parties begin negotiation activities, and they may request assistance from the National Mediation Board to help reach an agreement. And then the board also offers its services without the request of the parties. It imposes changes or strikes that can occur if a settlement is not reached unless an impasse.
No unilaterally imposed changes or strikes can occur unless what?
A settlement has not been reached.
If a settlement has not been reached, right? Unless what?
An impasse has been declared.
An impasse. You know what an impasse is? An impasse. When a person can't go any further, they're walking, they bump against an obstacle. That's an impasse. Something you can't go past it. That's why it's called impasse. All right? Impassable. All right? So once that happens, what?
Only if the parties reject arbitration.
Impasse has been declared by who?
The National Mediation Board.
Mediation Board.
545.
Thank you.
Then only if the parties reject arbitration of their differences does the NMB release them to engage in self-help. And finally, if the president believes a work stoppage would substantially disrupt interstate commerce, an emergency board can be convened to investigate the dispute and render a report.
And no changes or strikes can take place until when?
At least 30 days after the completion of an emergency board's report.
However, what happens?
Relatively long periods often elapse between when negotiations start and when an agreement is reached. Presidential boards are not infrequent. President George W. Bush convened an emergency board in 2001 to deal with threatened strikes at both Northwest and United Airlines.
So the exhibit 3.1, it gives you an overview of the appointment of a board that President George W. Bush created back in 2001. All right. So there's another board was created also by the RLA. Tell me about that board, and you can have a seat, Ms. Olatunji. Mr. Pollitt? Ms. Pollitt, you got your points for saying. Ms. Poe, tell me about the other board that was created.
The National Railroad Adjustment Board.
Tell me about it.
It consists of an equal number of union and management members and is empowered to settle grievances of both parties. If the board deadlocks on a grievance, it obtains a referee to hear the case and make an award.
Exactly. And what are awards? And what impact do they have?
They're binding and they...
When you say binding, what does that mean?
They're put together.
Ms. Prince. that whatever the decision is, right? Ms. Prince, whatever the decision that is reached by this board, then it has the rule of what? It has the rule of law, right? That means whatever they say goes. It's bound by both the parties are bound to follow what that award is. However, that award states. However, the prevailing parties, they may do what, Ms. Prince or Ms. Poe?
May sue in federal district courts to enforce the awards.
However, in most cases, how are most disputes handled?
Public law boards and special boards of justice.
And who are they? What are they involved?
They involve arbitrators.
Ad hoc arbitrators. What's an ad hoc arbitrator, Ms. Prince?
Rotating boards of neutrals who hear and rule on deadlock dispute cases.
Exactly. These are rotating boards of neutrals. A neutral is an arbitrator. Call a neutral magistrate. Somebody who doesn't have a stake in that particular matter. And they basically rotate throughout the country and rule on matters as opposed to, being there constantly like a judge, right? They're not sitting in one place like a judge, but they may go here and go there to basically resolve and arbitrate a dispute. And later in the semester, we're going to actually go through a grievance process with your groups, and your groups will have to basically present evidence and argue on behalf of either the union or the employer, one side or the other. So you're going to have that experience of going through that, all right? And so what is the NMB composed of?
3 members appointed by the president.
And Ms. Prince, what does it handle?
It handles representation elections, mediates bargaining disputes and requests, urges the parties to arbitrate when mediation is unsuccessful, interprets mediated contract agreements, and appoints arbitrators if disputing parties cannot agree.
So, as opposed to later acts, dispute handling under the RLA is what, Ms. Poe?
Highly detailed.
So, what does subsequent laws do? What do they do into mediation?
Leaves this up to the parties.
However, the RLA requires what?
That employees be organized by craft or occupational area. That's forcing employers to bargain with several unions, often having conflicting goals.
So again, and this is this distinction between the others. This one, you can have, again, employer having several unions within his or her company because they're different crafts. So, for example, if I am in a, let's say, school, you can have a union that represents the secretaries and the admin, right, people. You can have a union that represents the adjunct professors, and that's one of the things we're going to be talking about. We can have a union that represents the maintenance workers, right? So again, you can have multiple unions in the same company, the same organization, right? And that's, again, what the Railroad Labor Act provides, all right? There have been differences in what, Ms. Prince?
Differences in the way the law has been implemented in the rail and airline industries.
How so?
Inter-contract disputes in the airline industry are arbitrated as they are in industries covered by the NLRA. In addition, contrary to the technical wording of the law, some railroad supervisors supervisors such as yard masters are represented by you.
Very important. And this was, again, very important to go through the details of the RLA, because you can see that it was the first law in 1926. It laid the foundation for the other laws that followed. Thank you very much. Now, where's Ms. Poe and Ms. Prince? Mr. Scott here yet? Yes. Scott, all right. So, Mr. Scott, tell me about the Norris-LaGuardia Act of 1932.
The Norris-LaGuardia Act was the first law to protect the rights of the unions and workers to engage in union activity. The act forbids federal courts to issue injunctions against specifically described union activities and outlaws yellow dog contracts.
And what is a yellow dog contract?
In which employees agree that continued employment depends on abstention from union membership or activity.
So again, a yellow dog is considered somebody who has to basically, again, when you say yellow, what does that conjure up for you? Again, exactly, somebody who's afraid, right? And so these yellow dogs are people who have to essentially give up their right to join a union in order to basically work for an employer. That's what these, again, contracts were considered yellow dog, all right? It can't continue.
These contracts have been upheld previously by the Supreme Court. Since enactment, federal courts have strictly construed Norris-LaGuardia provisions. The Act recognizes that freedom to associate for collective bargaining purposes is the corollary of the collectivization of capital through incorporation. Injunctions and yellow dog contracts interfere with freedom of association. Besides the absolute prohibition of yellow dog contracts, injunctions against specific activities are prohibited regardless of whether the act is done by individual, a group, or a union. The following cannot be enjoined.
Okay, so we know, you can have a seat, that one,
5
thank you, that one, they can't stop work. What else can't they do? You can just yell out. 2 is what?
Participating in
They
union
can't
membership.
stop them from participating in union. What else cannot an employer do?
Paying or withholding strike benefits, unemployment benefits, and the like to people participating in labor disputes.
Exactly. So if you go on strike, the union can't say, I'm not going to pay you your unemployment compensation. 4th, what?
Providing aid or assistance to persons suing or being sued.
They can't. So they cannot prevent a union from supporting one of its members who is suing the company, right? Next, what?
Publicizing.
They cannot prohibit what? Publicizing what?
A labor dispute in a
So
nonviolent-
they can't. So when they say publicizing a labor dispute in a nonviolent manner, it's like what? They can't prevent you from putting out signs, right? Sending out emails, right? Doing a little phone chain, sending out press releases. They can't prohibit you from doing that. All of that is considered, again, nonviolent, non-fraudulent publication, right? They can't also prohibit what?
The assembling to organize.
Exactly. So if all the employees meet up in front of the company, that's okay. You can all meet up and have like a rally out in front of the doors, right? What else?
Notifying anyone that any of these acts are to be performed.
Right. There's again, nobody can say you can't talk. Again, some of the employers, one of the main ways that they break down union activity is by saying you can't say this to this person. You can't communicate. If you're on the job, you can't talk about union activities on this job. If you do, you're fired. Right? That's one of the things that this law protects. All right. What else?
Agreeing to engage agreeing to engage or not engage in any of these acts.
Exactly. Some companies can say, look, if you even agree to it, not even if you do it, but if you agree to do it, then you're fired. This law protects that. And what else?
Advising others to do any of these acts.
Exactly. So if you encourage somebody, you don't do it, right? You don't agree to do it, but you just encourage somebody to do it. Before this law was passed, you could be fired based upon you encouraging somebody to do that. Again, now this law is passed and the companies can't do that. The Norris LaGuardia also finally and completely laid to rest the 18th century conspiracy doctrine. And what was that conspiracy doctrine that we talked about in chapter 1? So you may remember the conspiracy doctrine? And you can probably be assured that this is going to come up again. Who is that? Conspiracy doctrine. That is, that if somebody goes on strike, again, it was considered that they were participating in a criminal conspiracy. Right? They were withholding basically commerce, right? Like the train workers, right? They were, essentially detaching, decoupling trains. Remember that? And they were refusing to basically, ship goods from one place to another. And the court considered that their activities, the employers argued that those activities consisted of a criminal conspiracy. And everybody who was involved in that conspiracy were illegally, were committing a crime. And they were not just fired, but they were also put in jail. Those are the things that, again, were put to rest. Thank you. By this particular Norris LaGuardia Act, all right? Let's talk about the Wagner-Taft-Hartley Acts. The Wagner-Taft-Hartley Act. Let's talk about those, which were, one, the Wagner Act was enacted in 1935, and Taft-Hartley was enacted in 1947, so they were about 12 years apart. And then in 1959, the Landrum-Griffin Act added additional provisions. And then in 1974, the jurisdiction was extended to, and special rules were enacted for private, nonprofit health care organizations, right? So what do these laws establish? Let's go to Mr. Solomon.
The acts establish a statutory preference for using collective bargaining to resolve conflicts in the employment relationship and for roughly balancing the power of management and labor.
So tell me about the Wagner Act.
The Wagner Act passed during a period of relative weakness for organized labor, only spoke to employer practices. As the pendulum swung in the other direction, Taft Hartley added union practices to the prescribed list. Finally,
and then the Landrum-Griffin Act did what?
Aimed to fine-tune the law to match day-to-day realities.
And so the heart of the Wagner Act, which is listed as Section 7, which embodies the public policy towards the individual worker and collective bargaining, it reads what?
Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection.
And what?
And shall also have the right to refrain from any or all such activities except to the extent that such right may be affected by the agreement requiring membership in a labor organization as a condition of employment as authorized in Section 8A3.
And also, which is key, they actually define several key terms. What are those terms, Stuart? What does it define?
Okay, employer is an organization.
So what are the terms?
Oh, the terms of employer.
One, it defines what is an employer, right? Second, it defines what?
Employee.
What is an employee? Third, supervisor. And fourth, what?
Professional employee.
And these all are important in the context of labor union organization, right? So let's talk about an employer. What is an employer as defined by the Taft-Hartley Act or the Wagner Act?
An employer is an organization or a manager or supervisor acting on its behalf.
However, federal, state, and local governments or any organization wholly owned by the government, except the United Postal Service, stipulate what?
They're subject to the RLA, and union representatives when acting as bargaining agents are excluded.
So again, union representatives are excluded from the idea of being a manager or a supervisor acting on behalf of the organization, right? In the context of federal, state, and local governments, right? Tell me about the casinos.
Casinos owned and operated by Native American tribes that primarily employ and cater to non-Native Americans are considered employers, while other Native American government ventures on reservation properties are not.
And again, there's a key case on that point. That's the San Miguel Indian Bingo and Casino that was enforced by the United States Circuit Court of Appeals in D.C. Circuit.
605.
Thank you. All right, tell me what an employee is.
An employee need not to be an employee of an organization in which the labor dispute occurs. For example, if firm A struck and employees of firm B refused to cross picket lines, even though no dispute exists with B, the workers at firm B are considered employees under the Act.
Okay, so again, you're not just looking at whether or not a person works for the employer. You want to, in the context of this, you want to look at whether or not this person's working for another company and is involved in labor activity in support of people who work for that company. All right? All right, so let's look at the idea of a supervisor. What's a supervisor?
The supervisor is an employee with independent authority to make personal decisions and to administer a labor agreement.
So again, this person is able to act on behalf of the employer and to, in the context of acting on behalf of the employer, administer various elements of the labor contract. All right? So what are some of the examples of personnel decisions that are included in the labor agreement?
Examples of personnel decisions include hiring, firing, adjusting grievances, making work assignments, and deciding pay increase. The supervisor may belong to a union, although this is unlikely, outside of construction or maritime industries, where groups of supervisors may not organize and bargain collectively.
So again, the union agreements generally prevent supervisors from becoming members of the union. So this kind of creates a kind of a tension, right? Because Ms. Latney, when you're working, what do you want to do when you're working? You want to get paid, but what else do you want to do? Advance. You want to do what, Ms. Latney? You want to get, it starts with a P, promotions, right? So you want to get promotions. You want to become ultimately you want to become a what? A manager, a supervisor, right? So, but if you're a union, you're in the union, right? Once you become a supervisor, then what happens? What happens when you become a supervisor, Ms. Ladden?
You get paid more.
You get paid more, but what happens in the context of you being a member of the union? You can no longer be a member of the union. You see this? So there's a little tension. So once you become a supervisor, in most cases, you can no longer become a member of the union because that is outside of the definition, right, of an employee that is protected by union rights. Lastly, professional employee. Sir?
A professional employee is one whose work is intellectual in character, requiring independent judgment or discretion, whose performance cannot readily be measured in a standardized fashion, and whose skills are learned through prolonged special instruction. Professional employees may organize, but they may not be included in a non-professional unit, while a majority of professionals voting in favor of inclusion.
And that is going to be a key point for the projects that you all are going to be dealing with. Because adjunct professors are what? Huh? They're professional employees because of what? They're intellectual in character, right? Are we not? They require what? Independent judgment, right? We have to determine what grade we're going to give you, right? That's going to be independent, right? Not the dean setting it. It's going to be us setting it, right? Next.
Whose performance cannot readily be measured in a standardized fashion.
Right. You can't say, okay, all professors have to treat, their students like this. All professors have to do this. They have to all come in at a certain time. They have to wear a certain type of clothes. They have to, you spend this amount of time in lecture, right? That's not the case. The professors vary, right? What else?
16.
And whose skills are learned through prolonged specialized instruction.
You can't just get out here and, and try to, wing it. You gotta have some skills, right? So that's the reason why adjunct professors are going to be considered professional employees. And as in professional employees, they cannot be automatically coupled in a union with people who are non-professional. So the admins who are not considered professional employees, we can't just join their union unless what? A majority of us vote and say that we should be a part of the non-professional unit, all right? So that's what that means. So let's go ahead and break here. We're going to go finish up on the NLRB. We're going to talk about what representation elections are. We're going to really be going through this right here and talk about in the context of what union organizing is all about. Then we'll get to the Land and Griffith Act. We'll get to the other federal laws and regulations that are involved with unions, and then we're going to get to the other laws, including affirmative action, which is not a law but more a policy. We get to that, and then we get to the agencies that are involved with implementing these laws, and there are quite a few. And then we're going to get into the idea of labor right now and come back. Let's come back since it's a little bit later. What time is it?
6:12.
6:12. So, what time is it?
Well, 6:12.
So we'll go 6:15 to 6:30. All right. All right.
Is that 6:30?
6:30.
Okay.
You pause it.